be surprised that it is a challenging place, if you do have a dispute, to get it resolved quickly and efficiently. In fairness to Myanmar, the country has only recently modernized its commercial laws. The Companies Act, for example, also in 2016, it's only recently put in place the new Arbitration Act, or the revamped Arbitration Act. There are still challenges. Probably the biggest one is that the court system is still in the early stages of ramping up to meet the needs of the increased investment into that country, and that means that if you're having to rely on the Myanmar courts, time isn't really on your side. It can be quite lengthy. Expertise, I mean, the availability of judges who have experience in difficult commercial areas, you know, mining, insurance, and those sort of things, aren't really. Let me be fair about this. We are at the early stages of that court system ramping up to deal with the new investment influx, if you like, and the particular specializations of the law that you require to do that effectively. So it comes back, you know, the real problems that investors will find going into Myanmar, like a lot of the more developing parts of ASEAN, again, it's certainty, speed, and the ability to enforce. But that's not really a surprise to anybody. I don't want to be seen as trying to sell arbitration here, but again, that a lot of people do find that is an easier way of making sure that cost-effective, certain, and easily enforceable way of resolving a dispute, because again, arbitration allows you to contract out of the court system. You can then make sure that you have a tribunal which has the relevant expertise in your area. There are timelines are more controlled. If you're before a court, they are in charge of the timeline. Arbitration for places like Myanmar is quite useful as well, because you can rely on things like, for example, the expedited procedure, which is available under the Singapore International Arbitration Centre rules, and other International Arbitration Centre rules can allow a very quick resolution of that dispute, if that dispute can be resolved in that way. So yes, there are a lot of challenges, but they're not unusual for investors who are investing in jurisdictions like that. Last year we had the new Arbitration Act come in, the revamped Arbitration Act. Now that was a sea change, because yes, Myanmar is now a party to the New York Convention. And just for your viewers who are not familiar with it, the New York Convention is probably the most successful international treaty next to the UN Charter. It allows for the reciprocal enforcement of arbitration awards. The great thing about the New York Convention is, in theory, if you have an arbitration award of a foreign arbitration tribunal and you want to enforce it in a convention state, it has the same force as the judgment of a court of that state. From a legal point of view, the new arbitration law in Myanmar adopts the principles of the New York Convention and the principles, I believe it's Article 35 and 36 of the UNCITRAL model law, allowing this seamless enforcement of a foreign arbitration award. So yeah, that was a sea change in terms of arbitration law in Myanmar.